afternoon, members. This is the meeting of the Bills Committee on Land Revenue Amendment Number 4 Bill 2017. We're scheduled to start at 2:30 p.m. It is time to start. We've also formed a quorum. Nominations for chairmanship, please. KK Kwok, Kenneth Leung. Any seconder? Seconded by Mr. Yip. Mr. Ken Leung, do you accept the nomination? Yes, I do. Thank you. Do I hear any other nominations? No. In that case, I declare that Mr. Kenneth Leung has been elected as the chair. Is there a need to elect a deputy chairman in case I can't make it? Please invite the public officers to join us.
Carrie, Mabel. Renta.
I would like to welcome the team from the Financial Services and the Treasury Bureau, as well as the Department of Justice. We are here to look at the Inland Revenue Amendment Number 4 Bill 2017. This is the first meeting of the Bills Committee. I understand that the crux of the matter is that we are having a new structure, that is the open-ended fund companies. I give the floor to the administration to brief us on the legislative intention as well as the content of the bill. Ms. Chen. Thank you, Chair. In relation to the Inland Revenue Amendment Number 4 Bill 2017, in relation to the policy considerations as well as the legislative intention, we did consult the Financial Affairs panel, but then I'm afraid that some members might not have attended that meeting. If you give me the permission, I would like to make use of a PowerPoint to present the information to you. We have seen a fast growth in the fund industry. We have also introduced a number of taxation measures. Asset management is growing rapidly. Towards the end of 2016, as far as the fund management business is concerned, the combined value was up to $18,293 billion. Most of them were publicly offered. In the past 5 years, for those authorized by the Securities and Futures Commission, the growth was 11% to a total of 2,203. The number domiciled in Hong Kong grew by 90% to 735. As to the hedge funds, that is those funds privately offered, between 2010 and 2014, the number of such funds managed by SFC licensed managers grew by 45% to almost 800. To further develop the industry, I'm sure many members present took part in the scrutiny of the Securities and Futures Amendment Ordinance 2016 in that year. The purpose is to put in place the legal framework for open-ended fund companies as a form of fund vehicle. We have to come up with codes and guidelines and subsidiary legislation. After the legal framework has been put in place, what we want to do is to diversify the fund platform. What is important is to attract the funds to come to Hong Kong, to create and register in Hong Kong. For such OFCs, they are mainly found in the UK and Luxembourg. and UK has a flourishing OFC sector. In Hong Kong, as a result of our tax treatment, most of them were offshore funds as a result of the tax exemptions. So the OFCs were mainly offshore funds, and they've been authorized by the SFC, and that's how they have been selling their products in Hong Kong. We would like to come up with 3 points in relation to our regulatory work. The SFC will be the principal regulator of the OFCs, and it must have an investment manager licensed or registered for the SFC's Type 9, that is asset management regulated activity, and the investment scope should align with Type 9 regulated activity. So this is in line with the regulatory work of the SFC. For Type 9 activity, we are talking about securities and futures. And of course, we understand that there will be more products like bank deposits, certificates of deposits, and foreign currencies. I have to point out that the real property will not be permitted. And in fact, this is provided for under the SFO. Now, I'd like to turn to the existing taxation regime. For the current bill, we're mainly talking about the tax concession. We believe that other than putting in place a legal framework, the tax treatment would also be important in attracting the funds to come to Hong Kong to domicile here. This is a table to show you the information. Currently, for those offered publicly, whether they are offshore or onshore funds, they get tax exemptions. For those privately offered, there is exemption for offshore funds. In other words, a privately offered OFC, if it is offshore, then it is exempted. So what is left is that if it is onshore but it is not publicly offered, that is, if it is offered privately, currently we do not provide any tax concession. In the light of the question of disparity in the tax treatment, it is found that the majority of the funds will opt for the offshore mode, so that they don't have to pay tax in Hong Kong. For the 2017-18 budget, the Financial Secretary announced that we should consider the matter and we should talk to the industry. That is, the profits tax exemption should be extended to onshore privately offered OFCs. We hope that we can work through the amendment bill so as to come up with a fair tax environment for the OFCs. This is the first time that we have such onshore OFCs being given taxation exemption. Now, what we're going to talk about will not just benefit the ecology, but at the same time, we have to put in place measures to prevent abuse. There are 4 conditions. The funds must abide by the 4 conditions before they will be considered for tax exemption. First of all, it should be onshore. I think, Mr. To, you will understand that we're talking about the definition of tax resident in Hong Kong. So, as far as companies or funds are concerned, we're talking about CMC, that is Central Management and Control. And then to prevent a small number of operators packaging their investment activities as such a fund, we are going to provide for the following. That is the ownership condition. And there are 3 main points. First of all, the number of investors. There will be a minimum number of investors to be required, and then the threshold of participation interest will also be imposed. Sorry, if I may interrupt you, I'm not sure whether I should put this question to the chair or the public officers. I have 3 or 4 meetings to attend at the same time. a clash of a few meetings. I think I understand what she's talking about. If I may just sort of ask a few questions, and they can either give an answer orally or in writing. I know this is not quite in line with the order. Well, I also prefer having that arrangement. I would rather have it quick because I've also got other meetings for this Bills Committee. If we haven't got anybody here, then I have to stop it. I will let you ask the questions. If you make me aware that we haven't got a quorum, then I have to stop the proceeding. Do you mind? Well, Mr. will be coming back. No, I have to go to Kowloon. I'm not going to impose a time limit on the Q&A. We've only got 2 members. I think 15 minutes maximum for Q&A. I don't need that much time. I'm not sure whether this is going to be the last meeting. I hope it won't be, because I do have some questions. Now, for the conditions that you have put up on the screen, I'm sure there must be a justification behind such a requirement. In particular, for the second point, the ownership as well as the type of investments permitted. You've said that real property would not be permitted. For condition 2 and condition 3, can you elaborate in writing the justification behind conditions 2 and 3? I want a written reply, unless the chair is to rule that we must get the answer right on the spot so that we can wind up the scrutiny today. Otherwise, I hope that there will be a written answer, and then I can follow up at the next meeting. I don't need an answer right away. There's also one other point that I don't quite understand. There were 4 boxes in the table. You are saying that you would like to achieve consistency. For the publicly offered funds, I think you're already exempting the onshore funds from tax payment. I think the purpose of the bill is to attract onshore funds to operate in Hong Kong. Why didn't we include the privately offered funds during the last round when the publicly offered funds were covered? So I'm interested in this question. I don't know. I can't recall whether I asked the same question last time. If I haven't, let me ask this again. That is, why didn't you cover the privately offered onshore funds last time that you covered the public funds? Please give a reply in writing. So for points 2, 3, and 4, you hope that the Bureau would give you a written answer. And now you are saying that for publicly held funds, exemption has already been granted, and you want to know why it hasn't been extended to the private funds as well. I will be brief. I expect more meetings, and for points 2, 3, and 4, I'm going to give a reply in writing. Now, for the bill, we're extending the tax concession. It is based on the Securities and Futures Amendment Ordinance 2016, which has been passed by the Legislative, which provides for the legal framework for the OFC. So the slide that I put up a moment ago might not have given you the details. We require qualified investment managers. We ask for certain types of assets to be the subject matter of investment. So No. I was interested in the tax exemption. Now, that takes me back to condition 2. You have to meet certain requirements before you can meet the requirement of non-closely held. We have also made reference to the practices elsewhere, like the UK and US and Australia. Well, they have also imposed certain ownership thresholds on different types of funds. In the light of such practices, at the time, we consulted the industry on the proposed condition. Of course, we have to make sure that this can be practiced by the sector.
Fund industry. We have talked to different fund industry associations. They told us that in other places of the world, what is the general scale of funds? Well, what are the number of investors involved? We have struck a balance. They think that this condition is designed within the frame of the industry. Well, how come that for publicly offered fund that it is exempted, whereas for privately offered it is not? If it is publicly offered, there are different forms, say unit trust and some mutual funds, and also some wholesale funds. From the information I have, the first time when we offered tax exemption to publicly offered unit trust dated back to 1983, and then it was in 1996. The exemption offered to unit trust publicly offered was extended to all publicly offered. That was in 1996. Yes, publicly offered. Well, for example, for privately offered, it would be exempted. And if tax exemption is available for publicly offered fund, then why not privately offered funds? I understand. What about explaining it from the perspective of anti-tax evasion? My understanding of publicly offered is that they will be passive investors of the public. How come back in 1983, the Securities and Futures Commission SFC granted this tax exemption instead of privately offered fund with only a handful of investors from the perspective of tax evasion? I hope the administration will give me a written reply. My last question. Well, the fourth box will be turned exempted. Before the exemption is given, can I hear from the Inland Revenue Department roughly how much in tax have they collected from these privately non-exempted funds, and how many companies? Because they will be exempted. We have to strike a balance. We want to avoid the criticism that why this group of people should be exempted. Will there be a collusion between the government and the business sector? So I just want to take stock of the current situation. Roughly how many companies? You don't have to name them. Well, if there is only one, then you may not be able to disclose the information because everyone will know. Just tell us roughly how many companies, and in the past 3 years, what is the total tax collected. I don't know if you can do a projection. In the future, how many companies would come to Hong Kong as a result? And what is the economic benefit? Say in terms of employment, this and that, growth in businesses. So that we will have a picture of of the situation, that we don't lose out too much, but we gain a lot. Give me the information on paper, please. Let me give you some information. Onshore open fund companies, open-ended fund companies. So far, there is none in Hong Kong. You said none, so they have not given any tax. They have not paid any tax then, right? So my guess and Mr. Jimmy Ng's is right, but we will try to weigh up the economic benefit. Maybe you think this is a very important factor to attract them to come here. Yes. There was nothing to start with. Any other questions? There will be plenty of time for the administration to prepare the document. Mr. Ronick Chan. I've asked some questions in the Financial Services panel, but I would like to ask them again. First, will the administration issue a tax resident identification to these companies? Last time, the administration said that they would closely monitor the development in the international arena to ensure that the issuance of tax resident identity will conform to international practice. So have you learned about the latest situation? In Hong Kong currently there are no such companies. So will you consider in the future issue tax resident identification to these companies or the other three types? What's the view of the IRD? Issuance of tax resident identification. Perhaps I will give you the principles. The central management and control of the company, is it in Hong Kong? The regulated activities, are they managed by Hong Kong investment managers, and these activities take place in Hong Kong, and whether there is some substantial and close relations. We checked the OECD to see if there are new directives or new viewpoints. We're aware that there have been different discussions and various rules being issued. We will closely monitor the situation in relation to privately offered funds, whether there will be specific stance taken by the OECD. So far, we don't see any that would affect our consideration. We will keep in view to see if they will change their stance or issue more directions. Otherwise, we may consider issuing tax resident identification. When the IRD considers the case, it depends on whether the applicant would like to obtain a tax resident status, because they need to consider where they should get the tax resident status that will benefit them most. I have a second question. The other time, the Deputy Secretary gave me a very detailed answer. When it comes to the ownership criteria, the DS said that in the right time they would review the proposal to attract the effectiveness of attracting OFCs to domicile in Hong Kong. So I'd like to ask, do you have a timetable? Because in due course can be very far in the distant future. It may be 3 to 7 years. So how long will it be? 1 year later, 2 years later, or after it's been implemented smoothly for quite some time? Thank you. We have to take into consideration market situation to see if it has achieved the effects we have in mind. We don't have any idea about timetable. As Mr. Chen said, We are working on the subsidiary legislation and code of the framework. We are discussing with the trade about details. We have talked to some representatives. When it comes to the code and the subsidiary legislation, we can fine-tune it after hearing the views from the trade. But when it comes to more important factors, say non-closely held criterion and the asset classes permissible, it has to be within the framework of OFCs. We would like to wait until the market has displayed some certainty in market condition before we work on that. However, this can serve as a blueprint of our future review. But I can tell you that we will stipulate a provision to empower the director for Inland Revenue to, by Gazettal, amend schedules, say Schedule 16B, through negative vetting. So if there needs to be any improvement, or if we need to do anything after the review, I hope that there is already a speedy and efficient channel in place. Last question. Last time, a suggestion from the trade was mentioned. Well, when investment managers of for these OFCs, the remunerations and the remunerations they receive are subject to profits tax, and we ask whether that can be exempted. We got an answer from the senior assessor. So I'd like to clarify. These fund companies, well, yes, it is perfectly reasonable that they have their profit from consideration or remuneration received should be chargeable. However, some carried interests can be exempted. What if the fees is charged not as management fees but by bonus? Then it can be exempted. However, my understanding that this kind of receipt should be chargeable. So, this loophole, where has it been plugged? Who can answer this question? Let me first tell you about our policy. In a panel meeting, we have had a discussion on this point, and I clarified there and then that our policy consideration is this. Well, we use the word loophole, but a more accurate way to put it is that Section 26 of the IRO mentions about profits from dividends may be exempted. This amendment is about OFCs. If they make investments in non-permissible asset classes, and if profits are generated, then they have to pay tax. And if you read it together with Section 26, so on the level of managers and consultants, if they receive bonuses or remuneration, then based on the interpretation of Section 26, they don't have to pay tax. So, under Section 50AJ bracket 3, we clarify that in the case of open-ended fund companies, if investment managers or consultants carry on the business of a fund and provide services, the consideration or remuneration is chargeable. This is to clarify the tax liability. It's not a new type of tax. And we did not clearly point out that it is a loophole. It's more on a technical level that there may be some matters that are not clear. Anything else? No. I have quite a number of questions to ask. This is not clause by clause, but I would like to talk about remuneration received by investment managers. You mentioned about 50 AJ bracket 3, 20 AJ bracket 3. If the open-ended fund companies does not have exemption for any reasons, then they will have to pay tax. Now that is not the case. If an open-ended fund company meets conditions and they have made investment in permissible asset classes, then they will have the exemption status for profit tax. However, they are still allowed a 10% de minimis limit. This is a flexibility. In other words, there is a limit of 10% for them to invest in non-permissible asset classes. So say for any given year, they may enjoy a tax exemption status, and on top of that, profits tax from non-permissible asset classes will be chargeable. 20 AJ bracket 3 says that the company may need to pay tax although it has exemption status. The consideration or remuneration the investment manager received under this section is chargeable.
Nothing.
I think, roughly speaking, I understand, but I would like to seek some clarification. Now, you talked about 10% allowance. As far as the OFC is concerned, if 90% are eligible investment, while the 10% falls outside the scope, that is Schedule 16, I want to know whether only the 90% is exempted from tax or whether the entirety is exempted from tax. There will be the status of tax exemption, but then for the non-16A investment, the profits derived from that would be chargeable to tax. Yes, chargeable to tax. For the investment manager to act for the OFC, again 90%, 10% would be the split. Now, if the dividend is the form chosen to give the investment manager consideration of remuneration, what is the status? It depends. For the consideration of remuneration, if it is a dividend, then it will be chargeable to tax. As we have said, for 16A and non-16A, whether it is or it is not, the difference doesn't matter here. So it is chargeable, despite the OFC meeting the exemption conditions, right? Now, if you are pinpointing the dividend, now an investment manager will charge a management fee, and then in the investment agreement, usually it will be said that 1% of the fund, 1% of the shares of the fund will be given, and it carries interest. So what about the initial chunk? Will it also be chargeable to tax, or is it tax exempted? For 20AJ3, you deal with the dividend. Now, what about if something has been given and it carries interest and is given to the investment manager? Would that be chargeable to tax? Thanks, Chair. Regarding your question, for the carried interest, if it is for the sake of the professional interest provided by the investment manager, then of course it is chargeable to tax. You talked about the carried interest. Why has he got it? The true nature is because that is in return for the provision of professional service, so it is chargeable. Now, of course, for the dividend, it is chargeable. This is in accordance with 20AJ3. For the carried interest, if it is sold, under normal circumstances, you may call it capital gain, though the circumstances may vary. But then the carried interest, at the time the carried interest is given, it is chargeable to tax once. What about the profits gained as a result of the sale of carried interest? Would it also be chargeable to tax? I'm not passing any judgment. I just want to give you the chance to comment on it. Well, if the dividend has been collected in the capacity of a genuine investor, then of course it is not chargeable. But then, what is the status for receiving the dividend? Is it because he is an investor or because he is an investment manager? Well, the OFC gives him 1%. Of course, if you say that that's in return for provision of service, then it's chargeable to tax. Well, according to 20AJ3, the OFC will also give him dividend because the manager has got 1% in the OFC. In accordance with 28J, is he still chargeable to tax? Is he regarded as an investor? Or is it because he has got it as a result of his service? Now, for the 1% given to him, you are saying that it is a remuneration for his service. But as a result of ownership or holding of 1%, he is entitled to dividends annually. What is the nature of the dividends? Because of his good management of the portfolio, or has he now become the owner of such an asset? I think it is complicating things. Maybe 28J cannot deal with such a scenario as a result of a drafting. Let me try. For 28J3, what we are targeting at, and as I have said in reply to Mr. Chen's question, this is because Section 26 of the IRO will say that the dividends will be exempted from tax. Now, we want to say that for the investment manager, for the remuneration obtained by the investment manager in the form of dividends, he should still be chargeable to tax. Therefore, to answer your question, I think your interpretation is correct. Now, under 20AJ3, what we try to deal with is that this person is getting a consideration or remuneration as an investment manager. And in subsection 4, we have also defined services. Just now, Ms. Hui from the IRD has said that had he been exercising his right as an investor and he's collecting dividends of a company, then it will be dealt with under another provision and not here. Now, of course, for this investment manager to collect 1%, and he get 1%, he get dividends from that 1%. As to the taxation liability later on, I don't think it is to be dealt with under this section. No, he exercises his investment management skills. He makes a profit for the OFC, and his service and the income derived from that is chargeable to tax. Now, because of his performance, dividends have been paid to him. If you don't define clearly, then we have to find out in what capacity he gets dividends out of the shares. Otherwise, as long as he's the investment manager, his dividends will also be chargeable. This will become mind-boggling. I don't think you can think of an answer on the spot. Perhaps I merely raised the question, and I want to have a clearer answer in writing from you, so that investment managers will have something to fall back upon. Mr. Chairman, for carried interest, the IRD has a departmental precious note. As a result of such a sort of complicated idea, that is consideration or remuneration, etc. Now for this OFC, I think for such a scenario, maybe it cannot be covered in the law. Perhaps it's better to be dealt with in the DPN of the IRD. I think if we can clarify it in the guidelines, it will be good for the sake of the investment managers, or when the OFC is designed, so they can have a better idea when they design their investment strategies. Well, I don't think I would like to have it expressly provided for in the law, but please show us the guidelines. I think for the I want to know about the interaction between the carried interest and your guidelines. I think Mr. Chen or myself will be asked about it. Members of the Bills Committee would also be asked the question. I don't want us to be put in a position in which we can't give you an answer. I'm not striving at changing the law. That's not my motive. For the DIPN 51. Earlier on, we encountered a similar problem for a offshore privately offered fund. As I understand from you, you also agreed that the law may not be able to cover all scenarios. Perhaps we can invite the IRD to come up with a similar DIPN to cover this scenario, and then we can sort of clarify the tax liability in relation to the consideration or remuneration. Mr. Chen, do you have other questions? If not, then sorry, I would like to ask more questions. Going back to table 4, or rather the table on page 4. For the investment vehicles, I want to know whether this will apply to funds set up as unit trusts. Yes. For Schedule 16A, in relation to the asset types, when compared with the hedge funds and the permissible asset types, I want to know whether there is a difference as far as the permissible investment classes are concerned. Chair, for the OFCs, they will be regulated by the SFCs. They will be licensed by the SFC, and they have to be managed by investment managers permitted to carry out Type 9 investment activities. So you can take a look of Schedule 16A, and basically we are modeling on Schedule 1, Part 1 of the SFO, like certificates of deposits, etc. So if you look at Schedule 16 of the IRO, I think the classes of assets are basically the same. But of course, the IRD has also come up with a DIPN. This is for the sake of offshore privately offered funds, like the hedge funds. Of course, they have a more detailed list of examples. We have taken a look and basically they are consistent in the future as to whether we need to come up with another more detailed DIPN for the OFCs so as to clarify the examples. I think it should be dealt with by the IRD. I think for the offshore hedge funds, last time the permissible asset classes were extended to the offshore private funds. Is that right? Yes.
Now, these onshore funds, the asset classes, I know that for private companies they are not allowed, but you did not say anything about whether there is any difference between onshore ones and offshore ones, or all private companies will be subject to the non-schedule 16A class. Well, for those in the SFO, OFC may invest in overseas private companies. However, local private companies is not listed as under this class. Don't you think that there may be some overseas private companies with assets only in Hong Kong? Then are they Schedule 16 class companies? Under 16A, OFC may invest in overseas private companies. Well, the shares. These companies may hold local assets. That means there are other ways for them to get elbow room. I'll leave it to you to think whether this is a loophole. Perhaps in the answer to Mr. To's question before next meeting, you may as well include why you need non-closely held criterion, because you don't want a certain investors to keep buying and selling securities, these high net worth investors, to circumvent and avoid tax. Well, my understanding of OFC is that they may not give direct instruction to fund managers. It's from this perspective that we understand why you set down criteria on governance and on the structure. Yes, thank you. We will elaborate on the matter you've just mentioned. In Schedule 16A, the permissible asset classes, it allows OFCs to invest in overseas private companies. When we consulted the trade, they are fully aware of the scope of asset classes. Some told us that they would like to get some flexibility in this regard. Just now, Chairman, you mentioned that there is a chance for these companies to own shares and assets in Hong Kong. And in a way, a small group of people may package this type of investment as OFC and evade tax. Yes, there's a risk and there is concern. We have previously mentioned that under the OFC proposal, there will be a basket of thresholds. That is, the person in question will have to get a certain number of investors. There needs to be a board. And they also have to give us the incorporation instrument, and they need to engage local investment managers. All these criteria is to ensure that the tax exemption will not be abused. We will constantly review this. whether for hedge funds under 16A and Schedule 16 that there will be incentives for certain people to do something about overseas private companies owning local assets. We have to strike a balance. We need to get the trade to think that we have not tightened our grip, and this will encourage people to come to Hong Kong to set up funds. You talk about a board. Would it be the same group of people as investors? Is that likely, or is there a chance? As far as I understand, the board may not have to be different from investors. However, the originator and the investors and their investment interests, there will be restrictions. Say for the originator, the investment is capped at 30% per person. And if it's an ordinary investor, well, it depends on whether there is any qualified investors. Say investment funds, we require the number of investors to be a minimum of 50. This is to ensure from the level of fund origination multiple safeguards, and will not be prone to monopoly by a small group of people. Mr. Chan, anything to say? I would like to talk about the definition of non-closely held. Perhaps I will wait till clause by clause. I have a few questions to ask then. Just now, Mr. To mentioned about economic benefit. I see that a lot of companies in Europe, Luxembourg, with a smaller population but a bigger area, they use this kind of investment for many years. How many OFCs have set up in Luxembourg? When it comes to fund managers, and other service providers, how many jobs have been created? Can you give us some information? We have talked to the SFC and the trade to ask them for information. With regard to Luxembourg, we don't have the latest figure. Recognized funds, over 50% of them are incorporated by OFCs. UK, as at May this year, recognized trust funds and OFCs stands at about 3,900 in number. About 75%, that is 2,900 of them, are OFCs. In Hong Kong, as I have answered Mr. Chan and Mr. To, currently there is no onshore OFCs. However, recognized funds of the SFC, as at end of March, there are 2,200 of them. 54% of them are offshore OFCs. That is, in Hong Kong, the business is growing fast. We have attracted a lot of funds to come to Hong Kong to distribute, but they mainly engage in sales and marketing. Luxembourg, UK and Europe, they have very mature development in terms of OFC, and we haven't caught up. We don't have a framework that attracts fund domiciliation, origination, as well as manufacturing. we would like to provide through train service. In this way, we will create a lot of jobs, and that this will be more than just engaging in sales and marketing. I don't have any other questions. Mr. Chan, any other questions? Before we go to clause by clause, I would like to deal with some things first. I'd like to hear from the administration. What have you done in your consultation, and what deputations or groups have you met? We need to consider whether to invite professional groups and deputations to come to a public hearing. We've had 2 rounds of consultation in 2016 and also in 2 rounds in 2017. We have included about several fund organizations, Hong Kong Society of Financial Analysts, PwSC, EY, AMA, and Association of Banks. We have submitted to the Liaison Committee of Tax of our proposal. This committee comprises of representatives of the trade and some professionals. We have also explained to them our proposed amendment. And these consultations took place in recent months. Mr. Chan, do you think we need a public hearing? I see from the paper, including that from the LegCo, that in general the trade welcomed the proposal. The comments received are mostly about technical matters. I don't think there is a need to conduct a public hearing. Perhaps we will go through technical matters when we do the clause by clause to see if they have been addressed. Perhaps the administration can tell us when we get there. Say, for example, the trade has made a comment and the comment has been taken on board. So we know whether the administration has addressed the issues raised. Can we send them a letter? That is, those professional groups, the trade, to see if they have any other views. We will also make available notices on the website. I don't incline to conduct a public hearing because this bill affects the trade and some professional groups only. Perhaps we will give them another chance to give us their comments in writing. I still have to deal with another thing. There will be another meeting. Are there 2 available time slots for the next meeting? One is the 16th of October 2017, a Monday from 8:30 to 10:30. Another slot is in the same week, the 18th of October 2017. First date is the 16th, a Monday. The other one is 18th of October, Wednesday, from at 8:30. I have to ask members to see which is better for them. From now to October, there is still about 2 months or so. We would have been able to receive all comments by then. I know that Mr. To would like to know a lot of things, but if we don't start clause by clause, it will be a waste of your time. I don't think we will be able to complete this rather complicated bill, but at least we can start first. If there are no objections, and I have spoken to government departments, when it comes to finances, I tend to use the English version in the clause by clause. Any views, Mr. Chan? No. I will use the English version. Of course, we'll look at the Chinese as well, but we will mainly use the English version. Perhaps, yes, you may start the clause by clause. Thank you.
Thank you, Chair. I would like to defer to Ms. Zhang. She will walk you through the clause by clause scrutiny. Yes, please. Thank you, Chair. A moment, please. The legal advisor has written to the administration, so when we come to the clause that you have raised a point, we don't mind you interrupting us, legal advisor. Ms. Zhang. Thank you, Chairman. As Ms. Chen, the DS, has said, the long title reads, amend the IRO to extend the profits tax exemption to certain open-ended fund companies in the central management and control of which is exercised in Hong Kong. There are 6 clauses altogether. For clause 1, we set out the short title. We have also provided for the commencement date, briefly speaking, for the entire bill, other than a particular reference to the derivative products, over-the-counter derivative products. We would like to bring this into operation on the day appointed for the commencement of the S&F Amendment Ordinance 2016, so that when we implement the OFC regime, the tax exemption will also be made available. For the OTC derivative products, well, what we have to do is to tie in with the Securities and Futures Amendment Ordinance 2014. We need to introduce subsidiary legislation, and we are still in the process of drafting such, so that will take place at a later date. Legal advisor, we have written to the administration, and just now the administration has also mentioned this point, that is a particular item in Schedule 16A will depend on the commencement of Section 53H of the S&F Amendment Ordinance 2014. We have earlier on written to the admin as to the factors affecting the choice of the commencement date of that section. We've received the correspondence from the administration. Yes, please tell us. At the policy level, we would like to align with the investment types in Schedule 1 to the SFO. For the commencement, we have to look at the subsidiary legislation to be made by the SFC. Well, in the past few years, we have already completed the drafting of 9 items of subsidiary legislation. The SFC is at the moment consulting the public about the regulatory framework for OTC derivatives market, in particular the regulation of the intermediaries. We need to amend the subsidiary legislation, and we need to consult the public. The SFC will consult the market as early as possible, hoping that we can finalize the procedures. It is expected that after Q2 of 2018, the SFC will be ready. So we take this opportunity to amend the bill, and we hope that there will be a flexibility once the work for concerning the derivatives is ready. Then we will sort of cover this item here. Please continue. Clause 2. The IRO is amended as set out in sections 3 to 6. Yes. Clause 3. We are going to amend the titles of section 28B. We have got a number of interpretations or definitions. We hope that they will be applied to the new sections in the IRO, that is from 28G to 28L, as well as a number of new schedules, 15, 15A, 15B, etc. Thank you. Yes, please continue. Clause 4. We are going to add new sections 28G to 28L. For 28G, there's in relation to the sub-funds of open-ended fund companies. We'd like to introduce segregation provisions. Under the Securities and Futures Amendment Ordinance 2016, it is set out clearly that should there be sub-funds under the OFC, the liabilities should be segregated. So what we are doing here under the IR Amendment Bill, we would like to continue with such an intention, and we are also coming up with the detailed tax-related provisions. For subclause 1, if an OFC has got sub-funds, then as far as tax assessment is concerned, each sub-fund will be regarded as an OFC on its own. Now, subsection 2, it is said that if a sub-fund is chargeable to assessable profits, again, it will come from that particular sub-fund. In other words, there will be a firewall between the sub-funds, and there won't be any. Sorry, if I may ask this question, for the loss suffered by sub-fund will remain with the sub-fund, and it cannot be offset. Yes, you're right, and in fact you found it in subclause 4. Yes, please continue. Sorry about that. Subclause 3. If an OFC has got more than one sub-fund, if a sub-fund is qualified for tax exemption while another sub-fund isn't, then the qualifying sub-fund will still enjoy the tax exemption. As I have said from the outset, there won't be the question of cross-tainting between the sub-funds. Now I come to the point you referred to, Chair. When a sub-fund suffers a loss, the loss cannot be used to offset the assessable profits of another sub-fund. Subclause 5, we are introducing a definition, scheme property. Well, this is to echo the OFC regime as provided for under the SFO itself. Yes, please continue. The next clause, 20H. An OFC may qualify for tax exemption. We set out the conditions and we talk about the types of profits to be exempted. For subclause 1, it says that if certain conditions are met, an OFC will not need to pay tax for its profits. For the conditions, you'll find them in subclause 2. Well, in fact, we have already sort of mentioned the conditions in our PowerPoint presentation. The company has to be a resident person because we've said that it should abide by the CMC requirement, centrally managed and controlled, and the company should be non-closely held. NCH, because as Chair, you have said, through this requirement, well, it means that we won't have individuals making use of an OFC to get exemption from tax in relation to certain transactions. As to which transactions will be tax exempted, Ms. Chen has given an explanation just now. For this regime, we are actually echoing what we have done when we amended the SFO. We have already, within that context, said that the OFC has to be managed by investment manager license for Type 9 activities. So the businesses should be aligned with the Type 9 activities. So for Schedule 16A, which you'll find in this bill, we give you the permissible asset classes. I understand that for a privately offered OFC, it may require a bit more flexibility. Therefore, we have this 10% de minimis. In other words, the OFC may invest in the non-permissible asset classes. However, for such investments in non-permissible asset classes, their profits will be accessible. Any questions? No? A moment, please. Thanks, Chair. Legal advisor, please. You talked about 20H2C2. It is said that you may invest in the classes in Schedule 16A. There's also a degree of flexibility. If it is outside the asset classes of 16A, you are permitted to have such investments up to 10%. We've written to the administration. That is, when they decided on the 10% limit, what factors were considered, and we would like to know about the basis of the 10% rule instead of other percentages. The administration has come back with a very brief reply saying that they have given consideration to the comments of the industry. I just wondered if other members have anything to say or if the administration would like to add to the answer. Yes, if I may, briefly. Well, when we talked about the asset classes, well, in fact, Type 9 asset management regulated activity was adopted as the basis in our discussion with the industry. There was a clear voice from the industry. A degree of flexibility is desirable, so they would be happy to have a certain percentage to be exempted. When we chose the actual percentage, we have not had any experience of such OFCs in the past, but then for offshore private funds, we believe that if they want to invest in private companies, they have already got a similar concept, though not exactly the same. So we have made it a point to consult the sector on this particular element. They agreed with us that there is a need for such a allowance. Therefore, in the guidelines of the SFC, we are going to lay down the requirements. For 20AH, bracket 2, or rather bracket 3, sorry, bracket 2, capital A and capital B, value of all the company's assets, will it be calculated on a daily, quarterly, or yearly basis? Of course, we do expect fluctuations from time to time because we're talking about the value. Now, do you expect the investment manager to calculate the value on a daily basis so as to seek exemption or what? How would it operate in reality? Ms. Chen, the intention is that at all times, you need to meet the 90%, 10% split. Otherwise, the whole thing will be accessible to tax. But I understand that the IRD, when it comes to assessment of tax, would calculate once at the close of the year. But in theory, you should meet the requirement at all times. Mr. Chen, the legal advisor asked a question about the 10% limit. Now, someone in the industry told me that of course they would have liked a greater threshold, a higher threshold. Probably after talking to the administration, the admin didn't want to give any room to maneuver, and the industry would like to have more than 10%, and somehow a concession was sort of agreed upon. For the 10% limit, how does it compare with the requirement in other jurisdictions? Mr. Chen was right in his comment. We consulted the industry. It was an interactive process. At the end of the day, if we were to strike a balance, while we do want to provide flexibility, on the other hand, it should be subject to a limit. So at the end of the day, the industry was aware of our position and they agreed with the administration. As to the types of investments as well as the ownership condition, we did take into account the overseas practices.
There may not be a similar limit, says 10%. The fund structure, regulatory framework of different places may be different. This bill targets OFCs. So we need to set a clear parameters for permissible investment classes. Legal advisor. There is something about drafting. If we refer to 20A bracket 2 bracket C bracket Roman 1, it's mentioned that we'll read the English out. It says
by the company in Hong Kong does not involve transactions in assets of a non-Schedule 16A class。咁因為嗰個 non-Schedule 16A class 咧，佢喺後邊嗰頁喺。
And for non-Schedule 16A class in the C2361, that page, you will see an interpretation, that is, a class that is not specified in Schedule 16A. Since there is this non-Schedule 16A class, it says that it does not involve transactions in assets. In English, there will be a double negative, which makes it difficult to understand. The administration said that this is a restriction, and they want to say that there is no such restriction. That's why it's worded this way. Members may want to consider whether there is any room for improvement on clarity. Who is to answer? Well, may I? Non-Schedule 16A class is a noun. It's a term, it's a type. It's non-Schedule 16A class. It may sound like it may sound like a double negative, but the term itself is a noun itself. First, we need to consider whether the term is clearly clarified. This is non-eligible asset class. So there needs to be a term built in the bill. And then we will say non-specified in Schedule 16A. It may sound a mouthful, but when we talk to the industry, when we talk about loss offsetting, say profits generated from 16A or its losses, can it be offset against a non-Schedule 16A class profit? We have heard what the legal advisor has said, but we would like to keep it this way. C 2361. Page C2361. It says it's non-Schedule 16A class. My question is, there is a non-Schedule 16A class. How come there is no Schedule 16A class? You will have to say schedules classified under Schedule 16A. Maybe there can be a definition of Schedule 16A class because there is already a non-Schedule 16A class. Is there a need? DOJ? This is from a drafting perspective. 20AH2C Roman 1. It echoes with Roman 2. It talks about trade, profession, or businesses that can't get involved in transactions of what. So something can't be done. And it says if you are involved in these transactions, there will be some restrictions. That's how it was laid out. It may be negative, but it echoes with what's said at the front. Legal advisor, Mr. Chen, I'd like to ask, what if using a positive way to put it? If you say non-16A class, maybe the scope will be bigger. And if you refer to 16A is narrower. So for 28H bracket 2 bracket C, you want to cover a bigger scope or a smaller scope? If you want to narrow it, then you should refer to one with a smaller scope. If you want it as wide as possible, then you refer to the wider one. So for 28H bracket 2 bracket C, it depends on whether you want to cover a smaller one or a bigger one. If you want to cover a smaller one, then use a positive way to word it. Trade, profession, or business carried on under Schedule 16A class. It's a positive way to put it, and it's of a smaller scope. But if the drafting intent is to cover all others, and I support it even though it's quite verbose. So I want to ask, you want a bigger scope or a smaller scope? Yes, I appreciate what the DOJ said, that C Roman 1 echoes with Roman 2. Yes, line 3, it says non-Schedule 16A class. If we use a smaller scope, say trade, profession, business carried on by the company in Hong Kong, in assets of Schedule 16A class, then it has delinked from Roman 2. Doesn't flow as well. That's why they use non-Schedule 16A class to echo Roman 2. That's my understanding. But for a layman, Roman 1 doesn't read well. Perhaps I will defer to the DOJ or the financial services. We don't have anything to add. The two members have given valid points. We might not be able to explain so clearly, but C, Roman 1 and 2 would like to negate something from a wider perspective. And as the chairman said, 1 is linked to 2. So we cannot just adjust it from the perspective of flow alone. I think that's a challenge of drafting. Ms. Chang, please continue. Next, we go to bracket 3. It stipulates what transaction by an OFC is exempted. This includes those specified in Schedule 16A. The second one echoes the SF Amendment Ordinance 2016. It says that the transaction will have to be carried out by a qualified person. You will find an interpretation. Qualified person is someone with a license for Type 9 regulated activity, and the transaction has to take place in Hong Kong. This is to ensure that the OFC is onshore, where there is central management and control in Hong Kong. Bracket 4. It states that during the process of qualifying transaction, if there are some incidental transactions which generates profit, under what circumstance these profits are exempted. We have used the concept in offshore fund regime. That is, if the percentage of amount of these incidental transactions is no more than 5%, then the profits generated is exempted. However, if it exceeds 5%, then only the part of incidental transaction profit is chargeable. This gives flexibility to OFCs. If it's 6%, then it's the 6% that has to that is chargeable, right? Not the 1% on top of the 5, right? That's right. Please continue. 6. Sorry, it's 5. When we consulted the industry, we are aware that sometimes it takes time for the funds to gear up, especially when we set down requirements. So they may not have, say, 5 or 10 investors on day one. So under AI, we will give them some flexibility, that is 24 months to meet the ownership criterion, that is the deeming provision. Under AH, we have to clarify. Under bracket 5, when they receive the first investor and for the 24 months afterwards, if the fund cannot meet the criterion of non-closely held, then the first 24 months deeming will be cancelled. Bracket 6. It caters for, if you give them 24 months, of course they will look for investors. In the 30th month, there is still not enough people. You won't assess them for profits tax for the first 2 years. So when it comes to the 3rd year, you have to assess profits for year 1 and 2. Is that right? Yes. Please continue. Bracket 6. When an OFC is incorporated and in the first 24 months they have met the non-closely held criterion, then in the following 24 months we require them to meet the criterion. Otherwise, the deeming for the first 24 months will be removed. The reason we impose this requirement is to avoid a small number of people or funds to use the first 24-month deeming period to round tripping to enjoy the tax exemption for the first 24 months. 7. Let me ask. If over a year there are a number of months that is not met, Will there be discretion exercised to deem that they have met the criterion? Say, for example, for certain months, some people drop out, and so the numbers fall short, and then afterwards they have found enough people. How do you deal with that? In 28J, there is a safe harbor arrangement. And I think what you have stated fits one of those conditions.
In operation.
Subclause 6. On a certain date, maybe the OFC can meet the non-closely held qualification, and then it has to meet the NCH for another 24 months. Well, on the one hand, we'd like to give the fund to have time to meet the requirements. On the other hand, we don't want to give room for abuse. We want to sort of reduce the likelihood of being abused, merely because we like to give it time to meet the requirements. Subclause 8, and that's about Schedule 16A, permissible asset classes. Ms. Chen has explained this point when she answered members' questions. If Schedule 16A has to be amended, it will be by way of a notice in the Gazette. And this is to be a gazetted notice made by the Commissioner. It is subject to negative vetting by the LegCo. So we hope that it will be a relatively efficient arrangement. Legal advisor. Thank you, Chair. For subclauses 6 and 7, just want to give some information to members. I've written to the administrations for subclauses 6 and 7. If a company ceases its business, we want to know about the impact. It is said that if the OFC ceases to carry on, then it will be regarded as it has never been in operation. And we have asked how the IRD will deal with the case. It is said that under the existing IRO, there is this requirement. That is to give the Commissioner a notice in writing 1 month in advance, and then the OFC will still be assessed to tax. Yes, we have given a reply to your legal advisor. We have cited Section 51(6) of the IRO. That is, the CIR should be notified within 1 month of such cessation. Not 1 month in advance, but within 1 month of the cessation. Any other questions? No? All right. Ms. Zhang, please continue. Subclause 9. And for the purpose of 28H, we have got some definitions here. First of all, the qualified person. That is, he has to be someone licensed by the SFC to deal in Type 9 activities. And then we also provide a definition for non-Schedule 16A class. I suggest that perhaps we should pause here. Probably Mr. James Toh and other members would like the Bureau to provide information in writing. I think we can't avoid having a second meeting. I've also noted that this particular bill is quite complicated. For 28I, it is not going to be simple. I don't want to have to stop midway in Cross AI. So why don't we start 28I at the second meeting? I expect that 1 more meeting would suffice. Mr. Chen, would you object? No, Chair. Can I give advance notice to the administration in relation to the only question that I want to ask about this bill? Please tell us the rationale. Now, for Schedule 16B, meaning of non-closely held, I don't find any problem with paragraph 1. For an OFC that does not have any qualified investor, then there are 4 conditions. I don't find any problem there. For paragraph 2, again, a number of conditions have been set out, but it says that the OFC must have 1 or more qualified investors. Say, for example, it so happens that there are 6 investors. It means that it can meet condition A. The participation interest of each qualified investor exceeds $200 million. Say, for example, we have 2 such investors, and then it says that for at least 4 investors of the company, the participation interest of each of them exceeds $20 million. If they have $200 million each, then they meet the requirements. And then the participation interest of each investor does not exceed 50%. No one is exceeding 50% because we have $200 million. And then it says that the participation interest of the originators and the associates does not exceed 30%. There will be a problem if the originator has got $200 million. So if the originator is $200 million and then the total is 480, then the 30% rule will be breached, may be breached. Yes, please go ahead. When we designed the rules for the originators and the qualified investors, they are 2 separate concepts. So it's a way to control the ownership. For the qualified investor, we have talked to the industry. Usually, when such a fund is set up, they will try to find some cornerstone investors. So we can allow for more than 1. Say, for example, there are 2, and then we will have so-called normal investors. So all the 4 requirements can be met. However, we have to be careful. Say, for example, there is 1 individual. Just now the chair mentioned somebody who is a high net value worth person. He is the originator. Maybe he exceeds 30% and then he can control the fund. Then we have to introduce certain safeguards. In other words, for the originator as well as the qualified investor, they may be institutional investors or cornerstone investors, but then there are 2 different concepts. We believe that it is necessary to maintain such a requirement. Mr. Chen, what I mean is that there is a qualified investor. His interest is exceptionally huge. Does it mean that he has to get another qualified investor who has a larger share, or someone who is not a qualified investor, but then the interest is also larger, so that the person involved will not exceed 30%? Correct. I understand the point, but then to such qualified investors, you are imposing a more stringent requirement than what you have provided for under the first paragraph. All right, perhaps we should pause here, and we have finished with 20AH, and 20AI isn't really that easy. I don't want to give the wrong impression that before all points have been addressed and we have rushed through the scrutiny. So we look forward to written replies from the administration. Any other questions from members? No? Then let's hope that you have a quiet summer recess, and we'll see you after the recess. I think the public officers may not have a long holiday, but still, please enjoy your summer holiday. Thank you.